Be happy, it is necessary for your understanding and learning. Because if you are not happy, your mind will not work positively. Be honest, study honestly, attend class honestly, be honest to your study, your work, otherwise you will never excel in your life. If you are honest, you are bound to succeed. Even if you are working in an organization and you are honest, you are working well, nobody can displace you, nobody can replace you, nobody will substitute you. But if you are not, and then the people will think of this, that this person is dishonest and I should look for better one. Be sincere and disciplined. If you are not sincere in your efforts, it's not going to pay dividends. And if you are not disciplined, you will never be able to achieve your targets. There may be little bit scare misses here and there may be little bit hurdles, delays, but you will achieve your target. I said follow routine. Otherwise you will find that someday you did not study at all and someday you studied something. This should not happen. You should follow a routine. If I have to do this, I have to do this. If I have to solve 25 problems, 50 problems a day, I will do it. If I have to write 2 answers of mains, I will do it. Whatever may be the condition. So follow routine. This is very, very important. And now do work in time-bound manner. Fix a target, achieve it. Put little bit extra effort. You cannot do work of 5 days in 50 days, and that is not going to pay you dividends and that is not going to fetch you rewards. So that should not happen, and that will disappoint you as well as the person dependent on you. So be sincere regarding that. Is this clear? And last but not the least, follow the directions of your coach. Follow the directions of a teacher who is sincere, of course. Like I'll be dealing with many cases in this class, but I'll not be giving all PDF of all cases. So you'll have to understand that how much you are required to study. If you start studying all cases on all topics, it will consume much of your time. So I'll send some cases in PDF and I will talk about certain cases in class only. I will not send PDF because that is not so useful. And if there is anything useful, I am discussing everything in class. So I hope till this point you have understood everything. If you have not understood anything, don't worry at all. Chinta nahi karna hai, chintan karna hai. You just think of that what I did not understand, why I did not understand. Let us revisit the topic. Let us revisit the class notes. Let us revisit the bare act. Let us revisit the question paper. Why it is happening? It may be due to loss of concentration. It may be due to lack of application of mind. So if you read it again and again, you are going to understand it. And towards the end of the class, you please ask the questions, whatever you have. We'll start solving question, as I said little later, because I want you to be little bit conversant with this CPC. Then only you can answer your questions well. If you do it at the outset without understanding many terms, many terminology, many phraseology, then perhaps you will have problem. तो थोड़ा सा इंतजार करके काम करना ज़्यादा अच्छा है, बट आप अनुशासन में रहें, खुश रहें, पॉजिटिव रहें, आपकी एनर्जी सही लगेगी और आप अच्छे से सीखेंगे भी. सीपीसी में ऐसा कुछ नहीं है जो आप नहीं सीख सकते और हम नहीं सिखा सकते हैं. देयर इज नथिंग लाइक दैट, बट फॉर दैट यू हैव टू मेंटेन लिटिल बिट डिसिप्लिन. That is why we have a kind of regulation here in the class that towards the end of the class you can ask the questions, and many of you have asked and I have tried to answer. I will try further also to answer those questions, and I will do it to the best of my ability, capacity, competency. So don't worry about that. So let us move further. We started our journey with the plaint, because whenever we go to file a suit as per section 26 of CPC, it is to be filed with the plaint. Every suit shall be instituted by filing a plaint. So we understood how a plaint is drafted. And in this drafting of plaint, we learnt about some rules of Order 6, some rules of Order 7. We have seen them in detail, especially Order 7, because it is related to drafting of plaint. Order 6 is little general regarding pleadings. Pleading is plaint for plaintiff and WS for defendant. WS means written statement. अभी मैं ऐसा कई शब्द बोलूंगा जो शायद आप नहीं समझ पाए. I will speak many such words which you may not understand at the outset, but you will understand with the passing time, because you will reach to a stage where that word will be now in process and that will be in practice, and that is what will make you better clear about those words. So have little patience, धैर्य धारण करेंगे, धैर्य से बहुत चीज सीखी जा सकती है. और क्लास प्लीज रेगुलर करिए. बहुत लोग क्लास से एब्सेंट रहते हैं. अभी भी देखिए आप बहुत कम लोग क्लास में आए हैं. So this is not fair. This is going to harm those people who are not joining the class on right time, because you will not understand the process, the stage. So I started with plaint, and in drafting of plaint, we learnt about this Order 6 and Order 7. Particularly in Order 7, when we saw that particulars of a plaint, Order 7 Rule 1, we talked of cause of action, that plaintiff must show cause of action. Otherwise, if you do not have cause of action, how the court can initiate action? You can just think of commonsensically. यदि आपके पास कोई वाद का कारण नहीं है, तो न्यायालय उस पर कोई कार्य नहीं कर सकता. बहुत सिंपल सी बात है. If you do not have a cause of action, what the court will do with that? So cause of action is the very heart and soul of the plaint. It is very heart and soul of the plaint. And plaint without this soul is a dead body. So plaint must have a cause of action. Just to reiterate this point, we read in Order 7 Rule 11 that if there is a plaintiff or a plaint is not able to disclose the cause of action, if plaint does not disclose the cause of action, then as per Order 7 Rule 11, plaint is liable to be rejected. Then there is nothing in it. In this context, we try to understand what is cause of action. And I said cause of action is bundle of facts. It is the media upon which you can claim a relief. If I have a cause of action, then I can claim the relief. If I have a contract, A has a contract with B, and contract is breached by B, and then A will file a suit for either a specific performance of that contract, or for compensation from that contract, or for refund of consideration and damages as well. So many kind of reliefs can be claimed on the basis of this fact that there is a cause of action. Is this clear? So cause of action is bundle of facts which a plaintiff is required to prove to avail the remedial right. If you do not have a cause of action, you cannot avail the remedy or relief from the court. Is this all right? Now cause of action is very important. Now in drafting of this plaint, we are required to show cause of action, and we are required to claim the relief also. If you can look into Order 7, Rule 1. Order 7, Rule 1. Now D says where the plaintiff or defendant is a minor. E. Facts constituting a cause of action. And G. E and G. And the relief is the plaintiff claims. The relief, so it must show cause of action, it must show relief. And then H also says where the plaintiff has allowed a set-off or relinquished a portion of his claim, then the amount so allowed or relinquished. If you have allowed set-off that is setting off of mutual debts, and relinquishing a portion of claim, that is waiving. That is waiving. You are not claiming that at all, you have relinquished. Is this clear? आपने वो claim छोड़ दिया, आपने set off allow कर दिया. Is this clear? So plaint के drafting में, in the drafting of plaint, you are required to show cause of action, you are required to put forward your different reliefs, alternative reliefs, remedial reliefs, and you are also required to state in the plaint that what kind of claim you have allowed as set off or what kind of claim you have relinquished, which you are not going to claim. So obviously it indicates that the drafting of plaint is all about cause of action, claim of relief, and claim as well. Is this clear? In this context, when we draft the plaint, then order 2 sage. Order 2 sage. That whenever you frame a suit, obviously it is referring to drafting of plaint, whenever you draft a plaint, then you claim everything there. You claim all reliefs arising out of same cause of action or one cause of action. If there is one cause of action, all reliefs and all claims should be claimed together. It is based on fundamental principle of civil jurisprudence. And what is the fundamental principle of all legal jurisprudence for that matter? Everywhere you find, either in CPC or in CRPC, that there should be speedy and fair trial. There should be minimization of litigation. अब कम से कम litigation हो, ऐसी व्यवस्था होनी चाहिए, ऐसा प्रयास होना चाहिए. तो कैसे करेंगे इसको? Interest Republicae ut sit finis litium. Everybody knows this. Interest of Republic lies in the fact that there should be an end of Interest Republicae ut sit finis litium. Interest of Republic lies in the fact that there should be an end to litigation. Nobody wants that litigation should continue, and there should be minimal litigation. This is what is the effort of law. This is what is the object of law, that there should be least possible litigation. Order 2, Rule 2, or Order 1, Rule 1, or Order 2, Rule 3, all these rules are oriented towards this simple object, that there should be an end to litigation, there should be minimal litigation, and that is why the rule is that from same cause of action, all the reliefs and whole claims should be claimed in one suit. If you have not done this, then generally you are barred to do it later on. We'll understand this, there is different rules saying different things, but at the outset, broadly we can say that when you file a suit, then you draft a plaint, and in that plaint you talk about cause of action. So out of that cause of action, whole claim and all the relief should be claimed then and there. If you claim again and again from the same cause of action in successive suits, it will give rise to multiplicity of suits on the same cause of action. Obviously, it will put defendant in difficulty, it will put court in jeopardy, and it will also not be plausible for plaintiff to successively sue on the same cause of action, on the same cause of action. This is not desirable either for plaintiff or for plaintiff will also be put in some kind of problem. So ये सबसे अपेक्षा की जाती है, सबसे पहले वादी से अपेक्षा की जाती है कि वो एक कॉज ऑफ एक्शन पर, एक वाद कारण पर एक वाद लाए और उसी में सारे रिलीफ, सारे क्लेम को एक बार में क्लेम करे. So splitting of claims and splitting of reliefs is not desirable. It will save the enormous time and energy of court. It will also be helpful for defendant because he will have to answer it all in the one suit. And it will also be better for the plaintiff, otherwise he will have to pay court fees again, he will have to plead again, he will have to draft plaint again, he will have to file another suit, another court fee, then again hiring the lawyer. Now this puts plaintiff also in problem. But there are many people who have tendency to file successive suit on the same cause of action. Just to prevent that situation that it should not happen, we have this order 2 in framing of the suit. So we'll read this order 2, rule 1, rule 2, rule 3, every rule. So let us see what is this. It says every suit shall, as far as practicable, be framed so as to afford ground for final decision upon the subject in dispute and to prevent further litigation concerning them. So basically this rule 1 is rule of comprehensive suit. Order 2, rule 1. Every suit shall, as far as practicable, every suit, be framed so as to afford ground for final decision upon the subject in dispute and to prevent further litigation. So what it says that you do not split things, you claim it at once. Now draft your plaint in such a way. So it is a kind of direction to the parties. It is direction to party. The party which we discussed in order 1, that you frame your suit in such a way to afford ground for final decision and to afford further and to prevent further litigation. To prevent further litigation, as far as practicable. In many situations it may not be practicable to decide all questions at the same point of time. It may be dependent question. Now the claim of mean profit आपको बताया था, profit which you generally earn by wrongful possession of the property. So the claim of mean profit will be decided on the basis of type of possession and the validity or invalidity of possession. So invalidity or validity of possession is one thing. If that question is itself in dispute, you may not ask for mean profit, so that has to be decided first. So there can be situation like that. There can be situation like that where you cannot make all claims, all reliefs at one point of time. Suppose there is a suit between you and me, and a consent decree is passed, and a consent decree is passed. Is this clear? And a consent decree is passed. Now in such a situation, if this consent decree is not obeyed later on by one of the party, there is consent or compromise. In many cases there can be consent decree. A and B goes to the court and there is dispute between A and B, and then there is some kind of compromise. On the basis of that compromise, court will pass an order, court will pass judgment, and then there will be consent decree. But later on one party does not obey that consent decree. He was required to give money to the other party, but he does not. He does not give money. So now in such situation, there is a new cause of action. There is new relief. that there is breach of this consent decree. This breach of consent decree was not there earlier. So can you claim that relief earlier? Can you now make that claim earlier? The answer is no. It is not practicable. First there will be consent decree, then for the breach of consent decree or non-obedience of consent decree, there will be another suit which will be filed by the party concerned. But when there was no consent decree, there is no question of breaking of this consent decree or breach of this consent decree. Is this clear? Order 2, Rule 1. Is this all right? Frame of suit. Every suit, as far as practicable, be framed so as to afford ground for final decision upon the subject in dispute and to prevent further litigation concerning them. It may be that we are fighting a case and we are not aware of interest of third party in that. That third party comes from foreign and he also makes a claim now. So there is a different cause of action, there is a different kind of situation which could not have been anticipated beforehand. We were not aware of that fact, that the property over which we are fighting is already gifted to that third party who is not here in India. So there may be many situations which can emerge later on. That is why we have chosen the word as far as practicable. But order 2, rule 1 is very basic rule which says that as far as practicable, you make all claims, all reliefs at the outset in one suit because there is one cause of action. Now order 2, rule 2 says suit to include the whole claim. Then it says in sub rule 2, relinquishment of the part of claim, and sub rule 3, omission to sue for one of several reliefs. So order 2, rule 2, sub rule 2 talks of claim, and order 2, rule 2, sub rule 3 talks of reliefs. Claim and relief, these are two different issues. So let us concentrate on that and let us see what it says. So you read order 2, rule 2, sub rule 1 first. Every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action. But a plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court. So what is the purpose? Purpose is to avoid multiplicity of suit. Purpose is to avoid double jeopardy to the defendant. Purpose is to save the time and energy of the court. Purpose is to save the plaintiff from the proof of same thing again and again. Purpose is very simple. And it serves all the interest of plaintiff, defendant and the system as well. So every suit, order 2, rule 2, sub rule 1, every suit shall include whole of the claim. Every suit should include whole of the claim. Every suit shall include whole of the claim. Which plaintiff is entitled to make in respect of the cause of action. To make in respect of the cause of action. So it's very simple that way. Every suit should include whole of the claim which plaintiff is entitled to make in respect of the cause of action. So this is one part, then there is semicolon. But if plaintiff relinquishes any portion of claim, then it is his choice. But if plaintiff relinquishes any claim, then it is his choice. Then it is his choice. Now later on he cannot make this claim. Later on he cannot make this claim. Order 2, Rule 2, Sub-Rule 1. Order 2, Rule 2, Sub-Rule 1. So आपको सारा claim करना है. If you leave any claim, then you cannot. Splitting of claim is not allowed. Then it says where plaintiff omits to sue in respect of or intentionally relinquishes. Omission or relinquishment. Omission means he left that. He omitted. And intentionally relinquishes जानबूझ के छोड़ता है. So either it is omission or intentional relinquishment. Omission means you did not notice and you omitted. You should be careful. You should be cautious. You are filing a suit. The whole system is being involved. So you cannot be negligent. So if you omit, if you do not bother or intentionally relinquish, intentionally relinquish, जानबूझ के, intentionally relinquishes. Omits or intentionally relinquishes, then the question arises, can you claim it later on? The answer is no. Splitting of claim is not allowed. This is to avoid multiplicity of suit on the same cause of action. This is to avoid, so what it says, a person entitled, now when a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterward sue in respect of the portion so omitted or relinquished. He shall not. He shall not. But plaintiff may, he shall not afterwards sue in respect of the portion so omitted. So it says that the effect is that it is divestive. It divests plaintiff, it divests plaintiff now to make that omitted or relinquished claim. It divests plaintiff now to make that omitted or relinquished claim. You cannot. Divest का मतलब उसको मुक्त कर देता है. It doesn't allow you. It doesn't allow you to claim now. Why did you omit this? You will bring that matter again and you will prove the similar facts and you will waste the time of the court and also put jeopardy or also create jeopardy for the defendant or put defendant in the jeopardy for the same thing. So this is totally uncalled for. We will not allow this to happen. Omission to sue for one of several relief. A person entitled now, sub-rule 2 talks of claim and this talks of relief. A person entitled to more than one relief in respect of the same cause of action may sue for all or any of such relief. Again, you are master of the suit, you are dominus litis. Plaintiff is dominus litis. So master of the suit, so he can omit claim, he can relinquish claim. Mhm. Master of suit. So he can relinquish claim, he can now leave claim, he can waive claim, and similarly regarding this relief. But if he omits except with the leave of court. So in this case, if you have taken leave of the court that I will claim this relief later on, in that case, he shall not afterwards sue for any other relief so omitted. So if you obtain the leave of the court, then you can file this another suit for claiming relief. Otherwise, if you have not sought permission of the court, then you are not allowed to claim that relief later on. So just let us understand this by a picture, which is very, very simple. Suppose there is a cause of action. In this cause of action, you have certain claim and you can get certain relief. Suppose you have claim of rupees 1 lakh. Your claim is rupees 1 lakh, for example, 1 lakh claim. And you are seeking the relief, let us say, of possession and mean profit. So in claim, the law is whole claim, no part claim. Whole claim. If he omits or relinquishes, can he claim later on? No claim later on. This law is very clear. Order 2, Rule 2, Sub-Rule 2. This law is very clear. But in case of relief, suppose I have two reliefs to claim right now. I claim this and in one suit in first suit I claim possession. Then there can be two situations here. With permission, that is leave. Leave means permission. With permission of court and without permission. If you have split the relief of possession and mean profit with the permission of court, then you can claim a relief of mean profit later on. Without permission of court, you can't claim this. You cannot claim. So splitting of claim is one thing and splitting of relief is another thing. Now, what is splitting of claim and splitting of relief? I have tried to explain, but let me give you example. Suppose there is claim of lakhs rupees and you do not claim whole 1 lakh rupees. First you claim 50,000 and then you again want to claim it by way of another suit 50,000. Can you do so? The answer is clear. No. Even with the leave of court, without there is no question of leave of court. So splitting of claim is absolutely barred. If you do not make a claim, your claim to make it later claim it by another suit is totally uncalled for, prohibited. You cannot. Now 50,000 you cannot get by way of another suit. But as far as relief is concerned, as I said, there can be many reliefs in a case. In breach of contract to sell the property or in breach of agreement to sell the property, there can be relief of a specific performance, there can be relief of possession also of the property. So if you have taken the leave of court, you can split this, you can claim it later on. Depending upon facts and circumstances, it may be desirable in a case that let us decide this relief first, and the party can seek such permission from the court. Let us concentrate on one relief first, and if this relief is available, then we'll talk of another relief, otherwise that is useless. So court may allow him to file another suit to claim another relief, that is permitted, but it is only with the leave of court, not without the leave of court. So this is in very simple terms order 2, rule 2. I'll go into explanation and examples also, but this is what is order 2, rule 2. इसमें लिखा भी है explanation for the purpose of this rule, an obligation and a collateral security for its performance. Now many cases when you take an obligation, then you give security that if I do not perform, then this security will be forfeited. For the purpose of this rule, of an obligation and a collateral security for its performance and successive claims arising under the same obligation shall be deemed respectively to constitute but one cause of action. So this performance of obligation and claim arising under the same obligation will be considered one cause of action. This is an explanation. This is a clarification, nothing great. Obligation and collateral security to perform will be considered one, because in both cases you are required to prove the similar facts, substantially similar facts. Of course, how will you know what is there is one cause of action, and how will you know that it is same suit? We'll discuss about these things. Now then it says in illustration, a let house to be at an yearly rent of 1200, the rent for whole of the year 1905, 6, 7 are unpaid. A sues B in 1908 only for the rent due for 1906. A shall not afterwards sue B for the rent due for 1905 or 1907. Why? This is the very simple general rule that there is one cause of action, there is one contract which is breached every year. Is this clear? A lets a house at yearly rent of 1200. The rent for the whole of, now see, the rent of 3 years are there. So should you split them? You should make, A shall not afterwards sue B for you should make whole claim at one point of time. Once you have waived your right to claim, then you cannot claim it later on. So there is an agreement, lets house at yearly rent. So this is yearly lease, one contract, breached 1905, 1906, 1907, 3 years. On the basis of this one contract, you want to make a claim. So 1200 into 3, you should make this claim. But what you did, that you made a claim for only 1906, you claimed only 1200 rupees. So the question is, in this fact situation, question is, can you claim 2400 rupees now? The answer is no. This is just to avoid multiplicity of suit on the same cause. Now see, there is same cause of action, one contract. Contract तो एक ही है. अब ये कॉन्ट्रैक्ट 1905 में भी ब्रीच हुआ, 6 में भी ब्रीच हुआ, 7 में भी ब्रीच हुआ. आपने 1 साल का क्लेम किया, बाकी 2 साल का नहीं किया. सो दिस इज हुज फॉल्ट? योर फॉल्ट. So court will not sympathize with you. Can you make claim for these 2 years later on? The answer is no. If you made claim for 1906, what stopped you to claim for 1905 and 1907? Why did you not make a claim? You should have made a claim. But if you did not claim, then you are bound to suffer. You cannot make claim later on. So in this situation, plaintiff cannot make claim of plaintiff cannot make claim of rest 2 years later on. This is bar of order 2, rule 2. एक ही contract था, तो you should have claimed together. Why did you not claim it? If you did not claim, it's your problem. It is your problem. It is your problem. So this is what is order 2, rule 2 in very simple language. Is this clear? This is in very simple language. So question is, do we file different suits for same cause of action? Now you raise question. Do we file separate suit for same cause of action? Answer is no. Answer is no. For example, claim or relief, both have the similar connotations. Speaking on relief, you can take another example. A is removed from his job. A is removed from his job. A files a suit in a court and prays that his dismissal is wrong and asks for declaration of dismissal being wrong. So his first prayer is that this dismissal should be declared wrong. This dismissal should be declared wrong. So he is seeking a relief of declaration that his dismissal is wrong and unwarranted. Is this clear? Is this all right? So dismissal is wrong, this is the relief which he is seeking. Now later on he comes and he asks for salary again. अरे भाई तो तुम सैलरी भी वही मांग लेते ना जहां डिसमिसल को रॉन्ग डिक्लेयर कराने की बात की, सैलरी तो तुम्हारी पहले से ड्यू थी. So you could have asked for the relief of salary also, which is there in arrears. So did you ask for this? No. So can you ask now? The answer is no. When you sought a declaration for this fact that my dismissal is wrong, then and there you could have asked for a relief of your salary in arrears. Arrears means ये इकट्ठा हो गया पीछे से, that is what is arrear. So you can ask for salary in arrears also. And if you do not ask this, then do you have any right to ask it later on? The answer is no. because this relief was available and you have not taken permission of the court. So in absence of permission of the court, if when you ask for declaration of dismissal being wrong, at that point of time, then and there, you could have asked for salary arrears as well, which you did not ask. Now on this point, to understand this law, we have a very famous case, Gurbaksh Singh. अब गुरबख्श सिंह को देख लेते हैं, फिर हम एग्जाम्पल्स लेंगे और। Gurbaksh Singh versus Bhuralal. The best way of understanding law is you read cases. And you read cases from case briefs, not from Dukhi and other sources. Gurbaksh Singh versus Bhuralal. I hope it is there in your this app also. Gurbaksh Singh versus Bhuralal. Gurbaksh Singh versus Bhuralal. AIR 1964, Supreme Court 1810. देख रहे हैं, केस ऑन ऑर्डर 2 रूल 2. Gurbaksh Singh versus Bhuralal is very interesting case, and it is one of the leading case on this order 2 rule 2. Now see, this case was case decided by 7 judges. This is 7-judge decision. This is 7-judge bench decision of Supreme Court. So you can think of how important it is. 7-judge bench decision of Supreme Court. Justice Gajendra Gadkar was the Chief Justice. 7-judge bench of Supreme Court. Justice Gajendra Gadkar, Vanchu, Hidayatullah, Mr. K.C. Gupta, Das, Engar, N. Rajgopal. Now you are not required to memorize the names. Now Gurbaksh Singh versus Bhuralal is very, now you should know this. अब देखो, तुम कभी कभी पूछते हो ना कौन से केस लिखें. अब जैसे ऑर्डर टू, अब आप क्या करो ना कि अपने नोट्स में, देखो मैं आपको क्लास में बताऊंगा, ऑर्डर 2 रूल 2 में ये फेमस केस है, इसको लिख लो कहीं. अब क्या करो ना, क्लास नोट्स में ना पहला पेज या दूसरा पेज या कोई लास्ट पेज में एक केस लिस्ट बनाओ. यू मेक ए केस लिस्ट ऑन डिफरेंट टॉपिक्स. जैसे मैंने ऑर्डर 7 रूल 11 पे आपको टी हरिवंदनम का केस बताया. सो यू शुड नो दैट. बहुत सारे केसेस नहीं ध्यान हो. अब देखो, आप कोई भी ऑर्डर 2 रूल 2 का केस पढ़ोगे, उसमें गुरबख्श सिंह वर्सेस भूरालाल मिल जाएगा. सो यू विल हैव एनफ आइडिया. अच्छा, ये वाला केस है एंड इट इज ऑलरेडी ए 7-judge bench decision. सो यू कैन जस्ट इमेजिन दैट दिस इज हाउ इंपॉर्टेंट. गुरबख्श सिंह वर्सेस भूरालाल. अब गुरबख्श सिंह वर्सेस भूरालाल में क्या हुआ, आइए देखते हैं. Plaintiff filed a suit for recovery. देख रहे हैं आप, Plaintiff filed a suit for recovery of possession and mean profit. तो possession का भी है और mean profit का भी है. And it was found that in a previous suit a decree for said profit was passed. In a previous suit a decree for said profit was passed. The case questioned on whether the cause of action was same in both the suit and whether the subsequent suit would be barred under the provision of CPC. The court ruled that plea of bar under Order 2, Rule 2 should not have been entertained by the trial court because the appellant had not filed the pleading in the civil suit in support of his plea. कोर्ट कह रहा है, ये सुप्रीम कोर्ट का डिसीजन है, कि बार अंडर ऑर्डर 2 रूल 2. सो यू कैन फ्रेम ए क्वेश्चन. Question is, when bar under Order 2, Rule 2 can be entertained. Can be entertained. This is the question. A bar under Order 2, Rule 2 should not have been entertained as appellant had not filed the pleadings in the civil suit in support of his plea. So I will answer the question and I will say answer is bar of Order 2, Rule 2 will apply bar of Order 2, Rule 2 will apply when defendant files pleading that is plaintiff here in his support. What I mean to say, that is what I will explain to you. Bar of Order 2, Rule 2 will apply when defendant files pleading in his support. When defendant files pleading in his support. Now what is the meaning I tell you? I tell you very simply that it means that bar of Order 2, Rule 2 will apply only if the defendant, when he raises the plea of Order 2, Rule 2, that is bar of filing a second suit, he will have to bring the plaint of plaintiff. And you know this, that when a plaintiff files a plaint and he reaches to the court with the plaint, and when court issues summons to the other party, then the court has to send copy of the plaint along with the summons. So now when defendant comes and he raises his objection at preliminary stage, that is without going into evidence and witnesses, etc., trial has not commenced. Trial will commence when issue will be framed in Order 14. अभी तो issue frame का stage नहीं आया. अभी तो plaintiff ने plaint file किया, defendant has been summoned, and defendant comes with this plea that his suit is barred by Order 2, Rule 2. Now court will ask him question, how, why? So defendant here has to bring the copy of plaint which he has been served to prove that this plaint filed in the second suit and this plaint which is in there decided in earlier suit is similar, it's same, it raises same cause of action, so it is barred. So जब तक आप plaint नहीं लाओगे, plaint जो यहाँ आपके पास है, तब तक आप कैसे साबित करोगे कि जो पहले का सूट डिसाइडेड है वो इसी बात से रिलेटेड था, वो इसी कॉज ऑफ एक्शन पे था, तो आपको प्लेंट लाना पड़ेगा. अब देखो, जब तक प्लेंट नहीं लाओगे आप तब तक आप, अब इसके लिए डिफेंडेंट का एवरमेंट आवश्यक नहीं है, इसके लिए डिफेंडेंट का WS आवश्यक नहीं है, इसके लिए अन्य चीजें आवश्यक नहीं, बिकॉज वी विल डिसाइड द क्वेश्चन ऑन द बेसिस ऑफ प्लेंट. अब ऑर्डर 2 रूल 2 में क्या बार है? On the same cause of action, you should not ask for relief again and again. Same cause of action. Which will show same cause of action? The two plaints. The plaint of earlier decision and the plaint in this case. So if you bring these two plaints, then the court will be clear to see this, that what is there. Is it same cause of action or is it different cause of action? Court will be clear. And there also, Just to know the cause of action, plaint is only required. It is not the defendant's WS which is necessary. What is necessary? That plaintiff's plaint, to see the cause of action. तो हम जब रिजेक्शन ऑफ प्लेंट भी कर रहे थे तो हमने आपको बताया था, if you remember my statement there when we discussed the question of rejection of plaint, then I told you that only thing which is required to be seen, to be gone into, is the plaint, not the defendant's written statement, not the defendant's evidence, not the defendant's averments. We'll see the copy of the plaint. We'll see pleading of the plaintiffs. We'll see pleading of the plaintiff, copy of the plaint in whole and his documents. And that is how will we understand that whether there is any cause of action or not. So, here to show that there is now same cause of action, you just bring the plaint right now and you show to the court that this is the same case which has been decided earlier or which is there earlier in the another suit. So, this is same cause of action, so rule of or bar of order 2 rule 2 will apply. So अब देखो आपको ये क्लैरिटी आ जाएगी जब आप ये केस पढ़ोगे जो मैंने बातें कही. I have told you in brief but you will have it in detail here. So you just see this case here and you just acquaint yourself with this case. This is very very simple. Plaintiff respondent brought. अब आपको कहा था ना कि इन चक्रों में नहीं पढ़ना, plaintiff respondent defendant appellant, अदरवाइज आप यही करते रह जाए. आप मोटी मोटी बात समझो कि एक व्यक्ति plaintiff brought a suit against another party for recovery of possession and for mean profit. So इनका क्या है? Recovery of possession and mean profit. Plaintiff claimed recovery of possession and mean profit on the ground that he was the absolute owner. Now, in the plaintiff made reference to a previous suit that had been filed by him and his mother, wherein a claim had been made against the defendant for recovery of the mean profit in regard to the same property. In regard to the same property. In the previous suit, mean profit had been decreed. In his written statement in the present suit, the defendant appellant raised a technical plea under order 2 rule 2. Before evidence was led by the party, the trial court decided the preliminary issue raised by the defendant. A preliminary issue hai. This issue of order 2 rule 2 is preliminary issue because we are not going into evidence. We are not into the trial stage. That is why we are calling it preliminary. ये प्रिलिमिनरी स्टेज है, प्रिलिमिनरी इशू है बिकॉज ट्रायल स्टार्ट नहीं हुआ. ट्रायल स्टार्ट होगा जब इशू फ्रेम होगा. तो अभी हम इशू फ्रेम नहीं किए. वी हैव नॉट फ्रेम्ड इशू येट. वी आर स्टिल इन द स्टेज वेयर देयर इज नो ट्रायल. ट्रायल विल बिगिन ओनली आफ्टर फ्रेमिंग ऑफ इशूज एंड इशूज विल बी फ्रेम्ड इन ऑर्डर 14. ये बहुत समय के बाद होगा. इशूज विल बी फ्रेम्ड लिटिल लेटर. Now we have filed the plaint, now we are framing this plaint. Basically we are into the question of drafting of plaint right now. Because in plaint drafting order 2 rule 2 is very very important. So we are in that first stage right now. When the plaint will be properly drafted and presented to the court, then the summons will be issued to the other party, then he will file WS, then the court will call both the parties for examination in order 10 and then there will be further process of order 11, 12, 13. And then issues will be framed in order 14. So order 14 का stage जब आएगा तब हम लोग trial में जाएंगे. Now we are not in trial process right now because we have not reached to order 14 and order 14 will come later on. Plaintiff will file plaint and then summons will be issued to the defendant and then defendant will file his WS, that is reply. Defendant के reply को WS कहते हैं, written statement. अभी हम बार बार बोलेंगे इसको. Then both parties will be asked to appear before the court. And they will be examined by the court, order 9 and order 10. And then they will be asked for further documents, etc. And then they will be asked for admitting certain facts. Then there will be production and impounding of documents in order 13. And then there will be framing of issues in order 14. So then trial will begin. So अभी trial शुरू नहीं हुआ इसलिए इसको preliminary कह रहे हैं. In the previous suit means before evidence was led by the trial court held. अब देखो trial court ने इसमें निर्णय लिख दिया, suit was barred. Appellate court held Appellate court ने कहा this order 2 rule 2 should not have been entertained because earlier civil suit 28 of 1950 had not been filed. So appellate court was smart enough. Had not been filed in the present case. Therefore, the appellate court set aside the order of trial court. Against this order, defendant preferred an appeal which was dismissed by High Court. The appellant obtained a special leave against judgment of High Court. So, special leave में चला गया. Article 136 of Constitution, you are allowed to go in a special leave to Supreme Court, SLP 136. Now, on this point held, a plea of order to rule 2 based on existence of a former pleading cannot be entertained when the pleading on which it rests had not been produced. This is the law. So you have to produce the pleading. It is for this reason that a plea of bar of order 2 rule 2 can be established only if defendant files in evidence the pleadings in previous suit and thereby proves to the court the identity of cause of action in. So there is requirement of bringing both the things before the court, pleadings in the previous suit on the basis of which you are claiming it, and this pleading. This pleading is already before the court. In other words, a plea under order 2 rule 2 of the court cannot be made out except on the proof of plaint in the previous suit, the filing of which is to create the bar. So आपसे कभी सवाल पूछा जाए कि what is required to be shown to attract order 2 rule 2, so you will say plaint of previous suit. Very simple. Plaint of previous suit along with obviously the plaint of this suit, but this suit plaint is there with the court. So plaint of previous suit. Is this clear? Now you read this case, plaint of previous suit. So what is the judgment in this case? Judgment in this case is that unless and until you bring plaint of previous suit, how can we take a decision? Is this clear? So you bring plaint of previous suit. Is this all right? Read cases, let me know. Did you understand everything or not? Let us take 5 minutes break, then we'll begin again. Let us take 5 minutes break, then we'll begin again. Is this all right? So if you are asked a question, that on what basis you will plead bar of order 2 rule 2, so you will say plaint of previous suit, because plaint of this suit is already there with the court. Plaint of this suit is already with the court. So court will have to show the plaint of earlier suit. Plaint of earlier suit. Is this clear? Plaint of earlier suit. Now there is another case, Jayanti Lal Chiman Lal Patel versus Vadi Lal Purushottam Das Patel. We are not interested in this particular matter that which kind of suit is this, but we are interested in this fact that Now see here, quoting this case, very importantly, this is again Gurbakh Singh versus Bhuralal. So it says, as the plea is a technical bar, it has to be established satisfactorily and cannot be presumed merely on the basis of inferential reasoning. So you will have to write down this. The portion which I am marking in Gurbakh Singh versus Bhuralal, you write down this as the plea is technical bar, so it has to be established satisfactorily. पहली बात ये है, as the plea is technical bar, it has to be established satisfactorily, number one. And number two, cannot be presumed merely on the basis of inferential reasoning. So this is the task of the person concerned to prove it before the court, and the person cannot expect the court to apply inferential reasoning It is for this reason that we consider that the plea of bar under Order 2, Rule 2 of CPC can be established only if the defendant files in evidence the pleading in the previous suit and thereby proves to the court identity of cause of action. Only if the defendant files in evidence pleading in the previous suit, that is basically plaint. This third point, defendant has to bring in evidence. What defendant has to do? What a defendant has to do, that is the question. So defendant has to bring pleading in the previous suit and he has to prove the identity of cause of action in the two suits. He has to prove identity of cause of the action. Now here what went wrong, I tell you, see in this judgment, the trial judge, however, without these pleadings being on record, inferred what the cause of action should have been from the reference to the previous suit contained in the plaint as a matter of deduction. Can it be done? No. This is not allowed. You cannot have deductions. Without the plaint in the previous suit being in the record, a plea of bar under Order 2, Rule 2, just as in the case of a plea of res judicata which cannot be established in the absence on the record of the judgment and a decree which is pleaded as estoppel, we consider that a plea under Order 2, Rule 2 cannot be made out except on the proof of plaint in the previous suit, the filing of which is said to create a bar. This is a very important observation. This is drawing analogy with the res judicata. That if you have to prove res judicata, then you will have to bring the judgment and the decree. Similarly, you will have to bring the plaint. So court defendant cannot invite the court to speculate or infer by process of deduction. This is not allowed. So यहाँ पर आप संक्षेप में लिख लें, just as in res judicata, Just as in res judicata, the record of judgment and decree is pleaded. Similarly here, in order to rule 2, similarly here, on order to rule 2, plaint of previous suit is to be proved. 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 So res judicata क्या करेंगे आप? Record of judgment and decree is to be pleaded. Here it is plaint of previous suit which is to be proved. Plaint of previous suit is to be proved. Jichuram and others versus Pyare Pasi and another. Jichuram case. Jichuram and others versus Pyare Pasi and another. देखो यहाँ इस केस में क्या आर्ग्यूमेंट है इन जिच्छूराम, though the bar of order 2 rule 2, अब ये लिखने की जरूरत नहीं है, as one of the issues expressly raised before the original court, the defendant did not prove the plaint in the previous rent suit. The only document proved on behalf are copied of order sheets in the execution case. Mr. Chatterjee, however, urged that from certain admissions made in the plaint in this litigation, this court should reasonably infer what was the nature of the allegation in the previous rent suit, and by this process of reasoning, decide whether the cause of action in the two suits was identical. Is this allowed? No. Can you prove this plaint on the basis of order sheet in execution case and admissions regarding plaint? Can you prove plaint? The answer is no. Plaint has to be brought before the court. Obviously, how you prove document, that is a matter to be discussed in evidence law. But here you should be clear that you are required to bring the plaint. Now, if you have to prove a thing, you bring the original. If you do not have original, you bring the certified copy. Plaint is filed in the court, so it becomes court's now basically plaint is drafted by you, but it is considered by court. Plaint is drafted in lawyer's chamber, but it is decided by court's chamber or judge's chamber. So basically, in that sense, it becomes now in that way the property of the court, because it is in the hand of court. And obviously, this plaint will be there now in the possession of the court also. So you can obtain a copy and you can produce it before the court. But that is a process of evidence act. I am not going into that right now. But you must understand that can we prove plaint in previous suit by this inferential method? That see, there is now reference of this plaint in this order sheet of execution case. No, this cannot be done. The court further says, again the court said here, it is mandatory to sustain a plea of order 2 rule 2 that the defendant is obliged under law to prove the plaint, and proof has to be as per the law of evidence. We have no hesitation in saying that ratio in Gurbakh Singh has been properly appreciated by full bench of High Court of Patna in Jichura. We are not able to sustain the conclusion arrived by High Court on the basis that the suit instituted by plaintiff appellant was hit by order 2 rule 2. Now, if you want to say that it is hit by order 2 rule 2, then you prove that, bring the earlier plaint. However, the controversy does not end here. The trial court and appellate court have adverted to the merits of the case, that is whether the tenant had constructed any permanent structure without the consent of land. It is manifest that High Court has not adverted to the same. There are other points also. If you are interested, you can read them further. Is this clear? So this plea of order 2 rule 2 cannot be proved in that inferential manner. It has to be proved by bringing the copy of plaint as per the law of evidence. Jayanti Lal Chiman Lal Patel versus Vadilal Purushottam Das Patel. Is this clear? So just now note down the important points. I'll be giving you more example to make you clear about this. Now let us take further example of order 2 rule 2. That is how you can understand it better. Now let us take first example. There is a suit for partition. There is a suit for partition. Clear? Plaintiff files suit for partition and abandons claim for account. And abandons claim for account, all right? Now, he subsequently files suit. He subsequently files suit for accounts on same cause of action. On same cause of action. Now question is it barred by order 2 rule 2 or not? Tell me. Is it barred by order 2 rule 2 or not? Answer my question. Is it barred by order 2 rule 2 or not? Clear? कई लोग पूछते हैं ना आंसर कैसे लिखेंगे, तो अब आपको ऑर्डर 2 रूल 2 का एक सवाल आ जाए, गुरबख्श सिंह हो गया, जयंतीलाल पटेल का केस हो गया, जयंतीलाल पटेल का केस बताया ना अभी आपको, गुरबख्श सिंह वर्सेस भूरालाल, एंड देन दिस जयंतीलाल चिमनलाल पटेल. So you just write that and write example also. Now, let us take another example. Plaintiff files suit for a specific performance. Plaintiff files suit for a specific performance and does not seek compensation and damage in alternative. Does not seek compensation and damage in alternative. Does not seek compensation and damage in alternative. Can he claim it later on? Now, the answer is clear, no. You could have claimed this unless and until, unless he has obtained leave of court in earlier suit. पहले ही सूट में यदि उसने लीव ले लिया है कोर्ट का, then he can do it, otherwise no, unless he has obtained leave of court in earlier suit. Leave of court in earlier suit. Is this clear? Unless he has obtained leave of court in earlier suit. Let us take another example. A mortgages 3 plots. A mortgages 3 plots in one mortgage. Mortgage is one. In one mortgage. A files suit for redemption. Redemption का मतलब है mortgage समझते हैं ना, mortgage. When you give your property for obtaining some loan. So mortgage is basically a secured loan. Mortgage, now when you mortgage your immovable property and then you obtain loan. Mortgage, आपने दे दिया प्रॉपर्टी को दूसरे को, कागज दे दिए, पेपर दे दिए. There are various kind of mortgage. So you have mortgaged your 3 plots in one mortgage. A files suit for redemption. Redemption means getting back, taking back, redeem, getting back, taking back. That is what is redemption, redeem. So A mortgages 3 plots in one mortgage and files suit for redemption of 2 plots. Can he file suit for redemption of third plot? Can he file suit for redemption of third plot? Can he file suit for redemption of third plot? Can he file suit for redemption of third plot? No. Because it is based on same cause of action. Keval Singh versus Lajvanti. Keval Singh versus Lajvanti. Now you are not required to remember this name of case. Keval Singh versus Lajvanti. EIR 1980 Supreme Court 161. Keval Singh versus Lajvanti. First suit First suit ended in compromise and consent decree. Ended in compromise or consent decree. However, it was not obeyed. It was not observed or obeyed, whatever. It was not obeyed. Second suit was brought. Second suit was brought alleging failure to carry out the terms of consent decree. Second suit was brought alleging failure to carry out the terms of consent decree. Question is it barred by? Question is it barred by Order 2, Rule 2? Question is it barred by Order 2, Rule 2? Question is it barred by Order 2, Rule 2? Yes. No. No, because this cause of action was not there. Here in first case, the cause of action was different on the basis of which consent decree was passed. Now consent decree is breached. So breach of consent decree is another cause of action. So I will write in response. अब कोई पूछेगा इसका आंसर कैसे लिखें? Suppose this is the question in your exam. How will you write answer? I will write law of order 2, rule 2, and then I will apply that law of order 2, rule 2. Obviously now Gurbakh Singh case I will quote versus Buralal, because that is very important. If I remember this case, I will quote Keval Singh, otherwise I will not write. No, there is a new cause of action. So you can write down breach of consent decree gives rise to new cause of breach of consent decree gives rise to new cause of action. Breach of consent decree gives rise to new cause of action. Breach of consent decree gives rise to new cause of action. Breach of consent decree gives rise to new cause of action. This is the answer, all right. So this is very simple that way. We should not worry at all, it's very simple. Plaintiff files a suit. Plaintiff files a suit for eviction. Plaintiff files a suit for eviction against. Plaintiff files a suit for eviction against. Hello. Plaintiff files a suit for eviction against defendant Plaintiff files a suit for eviction against defendant on the basis of lease. Plaintiff files a suit for defendant against, plaintiff files a suit against defendant on the basis of लीज, लीज पे दिया प्रॉपर्टी और वो नहीं दे रहा है. Now suit fails. It is not decreed. He does not get any relief from the court. So he files another suit on the basis of ownership title. He says that I have title to this property as owner, so I have the primary right. I am the owner of this property, so I have primary right to get my property back. And no person against my wish can be there. And he has been given this authority to be there for some time and his lease has expired, so I should get this land vacated. So is it barred? On order 2 rule 2, this is the question. Is it barred on order 2 rule 2? This is the question. Very good. No, it is not barred. देखो जिनको नहीं समझ में आया फिर से समझ लेंगे, कोई बात नहीं. No. You have to apply your mind. You cannot give answer without application of mind. This is suit for eviction on the basis of lease. So lease agreement is different agreement and this title is different. So the facts of the cases are different. So different cause of action is there. Different cause of action. जिनको नहीं समझ में आया उनको बता रहा हूं. भाई लीज के बेसिस पर हटाओगे तो you will prove lease. And on the basis of title, if you are evicting him and removing him, you will prove your title. So these are two different situations. You will prove different set of facts. आप different facts साबित करोगे. आप different facts साबित करोगे. You will not prove same facts. You will be proving different cause of action. You will prove different cause of action. Is this clear? You will prove different cause of action. Now, title is always against whole world, no? And lease is with respect to one person or two person, whatever. A question उठा, a suit has been filed by wife against husband for maintenance, in which only one relief was claimed. Now she brings a subsequent suit for declaration of charge for such maintenance. Can she file a subsequent suit? A very interesting question. Question is, wife files suit against husband. Wife files suit against husband for maintenance. Wife files suit against husband for maintenance. where only maintenance relief or claim was asked. Only maintenance claim was met. Now C brings subsequent suit. C brings subsequent suit for declaration. C brings subsequent suit for declaration of a charge for such maintenance. C brings subsequent suit for declaration of a charge for such maintenance. Can C file subsequent suit? That is the question. C brings subsequent suit for declaration of a charge. Charge means एक प्रकार से उस पे maintenance claim करने के लिए ना, for claiming maintenance, for maintenance money, you should allot a property or something like that, out of which some income will be generated and this will be given. This is what is called charge, creation of charge. Charge is a kind of security in that sense. A charge is created over a property for getting this kind of maintenance payment. So that is what is being paid by the lady subsequently. Maintenance claim तो पहले claim कर लिया, she claimed maintenance claim first and then she filed a subsequent suit for claim of charge for that maintenance money. You could have claimed this then and there. No, I give the answer. All ancillary reliefs should be claimed along with main relief. ये ancillary relief है. You claimed maintenance and now on the basis of maintenance you are claiming this charge. So all ancillary relief should be claimed. See, cause of action is same, maintenance. You just try to understand. Those people who have said yes, those people who have said no, I make both of them clear about this, that you must appreciate, my dear friend, you must appreciate that cause of action is same, maintenance. So in both cases it is maintenance claim. Charge is being claimed for maintenance. So if you have this maintenance claim, why you are splitting the claim or why you are splitting the relief unnecessarily? This could have been done in the first. Now this is leading to multiplicity of suit or not, tell me. And this is both related to maintenance itself. So you could have done it beforehand. See, lease and title, it is a different situation. I have given you lease, but somehow I could not prove my lease, there may be due to some technical defect or something like that. So I will bring my claim on the basis of ownership also, which was not required in the first case because I was interested in evicting you. So eviction was possible only on the basis of lease. But I could not succeed for some reason or the other. So I have another option available to me because I am the property owner to get my property back on the basis of ownership title. But here in this case, you have claimed maintenance. So in the same case, you could have asked for charge for maintenance. So what I said, the law is ancillary relief should be claimed with main relief. Ancillary relief should be claimed with main relief. It should not be split. It should not be split. Now, you will have to understand. जैसे मैं आपको एक और सवाल देता हूं. There is a plaintiff files suit for a specific performance. of transfer of land. And the suit is dismissed. And suit is dismissed. Plaintiff files suit for a specific performance of transfer of land and suit is dismissed. Suit is dismissed. Transfer fails. Transfer मिला नहीं उसको. Now, so there is bar upon transfer. He cannot file a suit for transfer now. Now he files a suit for a return of consideration money. For return of consideration money. Question is it barred under Order 2, Rule 2? ध्यान से सोच के जवाब दीजिएगा. Is it barred under Order 2, Rule 2? Is it barred under Order 2, Rule 2? चलो ये क्वेश्चन आपके ऊपर छोड़ते हैं आज. ये अच्छा सा सवाल है, इसका आपको रीजनिंग बताना है मुझे. मेरे को यस नो आंसर नहीं चाहिए. यू विल गिव मी रीजनिंग ऑल्सो. आई एम लीविंग दिस क्वेश्चन टू यू. I want you to think over this question and respond to my question tomorrow. I am not in hurry. You must understand. Different opinion is coming. But I will leave this question. I will not answer this today. I will answer it tomorrow. आप पहले बताना, मैं आंसर कल करूंगा. ठीक है. There is a different opinion. Prerna Dhingra says that he should have claimed in this relief as alternative relief. All right. Akriti Singh says could have asked in the main suit. Now there are other people. Kaisarnath, Utkarsh Ojha, Rajesh Khokhar, Neha Kumawat, Vaibhav Khattar, Asim Singla, they are all saying not barred. Gyanendra Singh says that it is barred. Pragati says no. Priyadarshini says no. Prashant says yes. Mafiz says no. Saurabh says no. Akanksha says no. Tanya says yes. Ashish says yes. Aditya says no. Very interesting, by the way. Very interesting. So I have got different opinion from different people, and I think both of them and both parties must have some justification this way or that way. So we'll see that justification tomorrow, not today. So you ponder over this question, give plausible reason. All right, really great. All right, really great. Great. This is really all right. So now, the question I am raising now, that to claim the relief of or to claim the bar of Order 2, Rule 2. Now you understood Order Rule 2. Order 2, Rule 2. What conditions are required to be proved ऑर्डर टू रूल टू को क्लेम करने के लिए क्या क्या चीजें आप साबित करोगे? देखो आपके बैरक में भी लिखा है, मोहम्मद खलील खान, महबूब अली मियां, वेरी इंपॉर्टेंट केस। गुरबख्श सिंह वर्सेस भूरालाल तो है ही। सो क्वेश्चन इज टू इन्वोक बार ऑफ order to rule to, what are essential conditions? Or what are different things to be proved by defendant to get bar of order to rule to invoked in a case? Or question is, on what evidence or fact bar of order to rule to can be pleaded? I am answering all the questions. पहले क्वेश्चन लिख लो। तुम्हें कोई भी एग्जाम में सवाल आई, इन्हीं का आंसर लिखना है आपको। आप कहते हैं ना आंसर राइटिंग, आंसर राइटिंग। आंसर राइटिंग इज सो सिंपल। If I know law, I can write beautiful answer. The problem is that we do not understand law and we just raise a hypothetical issue of answer writing, answer writing. And जिसको समझ में आता है उसको आंसर राइटिंग में क्या प्रॉब्लम है, तो कुछ है ही नहीं। लॉ के आंसर में यू हैव टू राइट लॉ एंड यू हैव टू अप्लाई लॉ। सो सिंपल, write law and apply law. And how can you write law? So read statutory provision and write in simple language. That is what Ambition Publications Bear Act has done. And read some cases, important cases. That is what Ambition Publication Bear Act has again done. So you just quote them. See, even in order to rule 2, what I have done, I have written meaning. Then I have written this Alka Gupta versus N.K. Gupta, Gurbaksh Singh versus Bhuralal, Pramod Kumar and another versus Jalak Singh and another, civil appeal number this, and then Burgo Industries, then Mohammad Khalil Khan. So I think this is more than enough to write in an answer. More than enough. How much you will write in an answer? Of course, for application, you should know the law well. So let us come to law and let us write that. So now let us address the question which I raised. So write down, for application of answer. This is the answer. For application of bar of order 2 rule 2, following conditions should be satisfied, or should be shown by the defendant. Seven-judge bench in Gurbaksh Singh versus Bhuralal, AIR 1964, Supreme Court 1810. Gurbaksh Singh versus Bhuralal. This is the citation. Yes. Said that for invoking, अब देखो केस लिख देने से क्या होता है ना, अथॉरिटी इंक्रीजेस. सो ओनली दैट केस विच इज वेरी इंपॉर्टेंट, नॉट ऑल केसेस. You are not required to remember 100 cases. If in a subject you remember 30-40 cases, that is more than up. 30-40 is on maximum site. और वो तो याद हो जाएगा, आप इतनी बार पढ़ोगे. सी आई सेड टी अरिबानंदन ऑर्डर 7 रूल 11. I am saying Gurbakh Singh versus Buralal, Gurbakh Singh versus, I am saying it again and again. So that is how you will remember. Even if you speak name of your friend 50 times, you remember. So similarly, case his name, you remember. You are not required to remember citation. Don't do this for God's sake. Gurbakh Singh versus Buralal said that for invoking bar of order 2 rule 2, for invoking bar of order 2 rule 2, should be satisfied or should be shown by the defendant. Following conditions should be satisfied, which was explained by seven-judge bench of Gurbakh Singh versus this. Said that he can't dijiye. This is already written. This is already written. Just you remove this point. This makes the whole thing complete. Now what are these bars? Let us understand that. This is where we are required to put full stop. Let us see them one by one. Number 1, second suit must be in respect of same cause of action. Identity of cause of action. Identity of cause of action. Same cause of action. Second, where plaintiff where plaintiff is entitled to more than one relief, where plaintiff is entitled to more than one relief, where plaintiff is entitled to more than one relief and omits to sue for a relief for which second suit has been filed. Without the leave of court. If it is with the leave of court, then it is permitted. Without leave of court. Leave means permission. And this permission has to be sought in the first suit. Here, permission, I am giving clarity, here permission is sought in the first suit, not in the second suit. Second suit means you are filing suit with the permission which you have already obtained in the first suit. अब फर्स्ट सूट में ना परमिशन लेंगे तब सेकंड सूट फाइल करेंगे, तो पहले ही वाले सूट में परमिशन लेना आपको कि देखो जी ये वाला रिलीफ मैं क्लेम नहीं कर रहा हूं, आई विल क्लेम इट लेटर ऑन, सो यू प्लीज ग्रांट मी लीव. So what I said, that the leave will be asked or leave will be sought in the first suit, where you can pray to the court that see I am not seeking this relief right now, I will claim it later on if you permit me to do so for reasonable ground or for valid ground. So court may permit you to file another suit in same cause of action to claim another relief in subsequent suit. So if it is allowed by the court in the first suit, because you had relief in the first suit, so then you can file a second suit with the leave of the court. Is this clear? Then earlier suit is on the same cause of action, no? Earlier suit has been decided on merits, that is, not dismissed on preliminary grounds, not dismissed on preliminary grounds. Not dismissed on preliminary grounds. Preliminary grounds like plaint is rejected on the ground that plaint does not disclose cause of action, or there is no jurisdiction, or something like that. No court fees has been given, or no process fee has been submitted, something like that. So these are not decided on merits. You did not go into the case. Decided on merits means where you entered into the case, where you heard the case, where you heard the parties, you have the evidence, then you go into the question of the case and then you decide on the basis of evidence. When you have rejected it on the face of it, that is preliminary rejection is there, then no question of decision on merit. So earlier suit has been decided on merit, and I tell you, generally it will apply in case when their case has been decided in the first suit and then you bring the second suit. But I must let you know, this is not only res judicata, this is res sub judice also. So if the suit is lying still, even then this can operate. So I must clarify that bar of order 2, rule 2 applies not only bar of order 2, rule 2 applies not only in case where suit has been decided, where earlier suit has been decided, rather it can be invoked in a situation where earlier suit is lying on the same cause of action, not decided. On the same cause of action. Earlier suit is lying on the same cause of action. Lying, It's not decided. So whether it is decided earlier or it is lying in the court, दोनों परिस्थितियों में, in both situation it will apply. So what I said, let me explain again. If earlier suit is there and it is decided on merits, same cause of action is there, you ask for another relief related to same cause of action, suit is barred. Because suit is earlier decided on merits. But in a case where suit is not decided, earlier suit is still pending in the court, and now you bring another suit and you want to claim on the same cause of action a relief, will it be allowed? The answer is no. So this order 2, rule 2 is applicable in a case where suit has been decided. It is also applicable in a case where suit is lying in the court. दोनों परिस्थितियों में ये लागू होगा. गुरबख्श सिंह वर्सेस भूरालाल का केस. देखिए आपको एग्जाम में ऐसे सवाल आते हैं तो यू विल राइट द सेम. गुरबख्श सिंह वर्सेस भूरालाल. I have drawn your attention towards difference between order 2 rule 2 and order 2 rule 3. Order 2 rule 2 sub rule 2 and order 2 rule 2 sub rule 3. देखो गुरबख्श सिंह को पहले समझ लो आप, मैं आ रहा हूं उस पर भी, मैं डिफरेंस पे भी आ रहा हूं, डोंट वरी. बट दिस इज क्लियर. Is this all right? Is this all right? So you understand one thing, that bar of order 2 rule 2 applies when there is identity of cause of action, and not bar when there is different or distinct cause of action. When there is a different or distinct cause of action. When there is different or distinct cause of action. When there is different or distinct cause of action. Is this clear? This has been said in Keval Singh versus Lajvanti, also consent decree, I told you, compromise decree, different cause of action. Example, Keval Singh versus Lajvanti. Consent decree case. This is how we can remember case, consent decree case. Keval Singh versus Lajvanti. Let us see further cases in your Bear Act also. Muhammad Khalil Khan versus Muhammad Ali Mia. Muhammad Khalil Khan, this is famous case, versus Mahbub Ali Mia. AIR 1949. Privy Council. This is Privy Council case. PC means Privy Council. 78. Muhammad Khalil Khan versus Muhammad Ali Mia. Muhammad Khalil Khan versus Muhammad Ali Mia. Privy case laid down the following principle. The correct test in cases falling under Order 2 is whether the claim in the new suit is in fact founded upon the cause of action distinct from that which was foundation for the former suit. If the evidence to support the two claims is different, then the cause of action are also different. So it says, number one, if the evidence to support claims, if the evidence to support claims support two claims, that is two suits, two claims in two suits. I have added, if the evidence to support two claims is different, then the cause of action is also different. Then the cause of action is also different. Like Lajvanti case, Keval Singh versus Lajvanti. Cause of action is also different. Now, when consent decree was passed, cause of action was different because there was some dispute between the two parties. Then they consented, then the decree was passed. But when consent decree was not obeyed, then there is a different cause of action. So you will prove that there is a consent decree which has not been obeyed in second suit. In first suit, you will prove that there is a cause of action, that we gave money and we took money and he did not pay and I did not receive, and on that basis dispute arose and consent decree was passed. But in second suit, when consent decree is not obeyed, it is breached rather, the obligation is not performed, then you will prove that there is a consent decree and this consent decree is breached. So these are two different cause of actions. Cause of action is different. If the evidence to support two claims is different, then the cause of action is also different. Cause of action is also different. Muhammad Khalil Khan versus Mahbub Ali Mia. AIR 1949, Privy Council, page 78. Now, then it says, second point, very important. The cause of action has no relation whatever the cause of action has no relation whatever to the defense that may be set up. Cause of action has no relation whatever to the defense that may be set up by the defendant that may be set up by the defendant, nor does it. So it has nothing to do with defense of defendant. It has only to do with plaint in previous suit. So if the two plaints are now same or similar and cause of action is same, order 2 rule 2 will apply. It has nothing to do with defense of defendant. What defense is pleading, how I am concerned, that may be set up by the defendant, nor does it depend on relief prayed for by the plaintiff. Prayed for by prayed for by the plaintiff. So it is not dependent also on the relief. So if there is same cause of action and you are pleading different reliefs, will it be saved by order 2 rule 2? No. It refers to, media upon which, it is given in your Bare Act also. Those who have some problem in writing, they can see their Bare Acts. Rather, it refers to media upon which the plaintiff asks the court to arrive at a conclusion in his favor. To arrive at a conclusion in his favor. Rather, it refers to media upon which the plaintiff asks the court to arrive at a conclusion in his favor. To arrive at a conclusion in his favor. Rather, it refers to media upon which the plaintiff asks the court to arrive at a conclusion in his favor. Is this clear? Because that will decide the cause of action. Whether there is identity of cause of action or not, that will be decided on the basis of this fact that what averments you have in your plaint in earlier suit and in second suit. What are the contents? So, media upon which the plaintiff asks the court to arrive at a conclusion in his favor. So, media, that is the fact. The fact and the evidence in plaint which is being referred there. Plaint does not include evidence, but you obviously refer to the document, you write averments on your side. So that is determinative. The contents of the plaint, this in earlier suit and in later suit, that is what is determinative. So that is what is being said, media upon which the plaintiff asks the court to arrive at a conclusion in his favor. So that is what is relevant. Defendant ka defense nahi dekhenge. Plaintiff's relief is also not required to be seen. No. We are not concerned. We will see the cause of action. We will see the media upon which the plaintiff asked for relief. We will see what bundle of facts he has brought. So that is what is Muhammad Khalil Khan versus Muhammad now Ali Mia. Is this clear? Then Virgo Industries. Virgo Industries Limited versus Venture Tech Solutions Private Limited. Virgo Industries versus Venture Tech Solutions. Versus Venture Tech Solutions. 2013, one SCC, one SCC, page 625. Virgo Industries. Virgo Industries. The apex code distinguishes between order 2, rules 2, rules 2, sub rule 2 and 3. ये तो पहले ही मैंने बताया भी आपको claim in relief वाला. I made a picture and I told you. The apex court distinguished two sub-rules, order 2, rule 2, sub-rule 2 and order 2, rule 2, sub-rule 3. And said that they contemplate two different situations. Two different situations. One talks of claim and another talks of relief. First one deals with claim which plaintiff omits or relinquishes. And second, where plaintiff relinquishes relief. Out of several reliefs. Out of several reliefs. It is only in the latter situation where plaintiff can file a subsequent suit. It is only in latter case, that is relief case, that is in relief case. What is only in latter case that plaintiff it is only in latter case that the plaintiff can file another case, can file another suit. Can file another case or suit can file another case or suit seeking a relief omitted in seeking a relief omitted in earlier suit. Relief omitted in earlier suit. In earlier suit, provided at the time of omission, we have already read it in the very beginning, provided at the time of omission, quotes, leave was obtained. Leave means permission. Leave means permission. Leave was obtained for it. So I said, provided at the time of omission, quotes, leave was obtained. That is in earlier suit. That is in earlier suit. Is this clear? Is this all right? So I hope order 2, rule 2 you have understood little bit. We'll further discuss this thing tomorrow and we'll finish this. And we'll move further. In the meantime, you read cases which I have given you in your app also. And I'll bring some more cases because order 2, rule 2 is very, very important. Very, very important. Very, very important. ये क्या गया हुई? What is this? All right. If you have any question, please ask me. I hope you appreciate the fact that not disturbing class in between is so good and is smooth that it creates an environment where you can learn a lot very easily. Any question of anyone, please? Anyone having any question? Yes, sir. I am waiting here. If he asks for maintenance pendentility, then it will be bar. Maintenance pendentility. Maintenance होता है, pendentility क्या है? Maintenance का claim था, तो maintenance का claim है तो आपको उसी claim में charge मांगना था. Maintenance pendentility हो या कोई भी maintenance claim हो, फिर आप उसके लिए बाद में को चार्ज दो, तो हम लोग सूट पड़ रहे हैं ना. क्या सब्सिक्वेंट सूट फाइल कर सकते हैं? मेंटेनेंस क्लेम ले लिया, आप उसके लिए आप चार्ज के लिए कह रहे हो. ये पेंडेंटिलिटी में भी हो सकता है. थर्ड पॉइंट ऑफ कंडीशन विच इज रिगार्डिंग मेरिट्स. मेरिट्स में यही कहा कि यदि केस मेरिट पर डिसाइडेड है तभी ना. अब यदि प्रिलिमिनरी ग्राउंड पे केस रिजेक्ट हो गया, जैसे ज्यूरिसडिक्शन का ग्राउंड है, कोई ग्राउंड है, तो मेरिट में नहीं गए आप केस के. मेरिट में तो केस के तब जाएंगे जब आप केस में एंटर करेंगे. यू विल टेक एविडेंस ऑफ बोथ साइड्स, देन यू विल हियर द मैटर, देन यू विल हियर द आर्ग्यूमेंट, एंड देन यू विल रीच टू ए केस, रीच टू ए डिसीजन. सो दैट इज व्हाट इज ऑन मेरिट्स. So can you explain please third point of condition? Third point of condition तो यही था, which is regarding merits. If she asks for maintenance मैंने बता दिया. कौन से कंडीशन है जिसमें कोर्ट के लीव बाद भी वी कांट सू? ये कौन सा सवाल है? कौन से कंडीशन है जिसमें कोर्ट के लीव, यदि कोर्ट लीव ग्रांट कर दी आपको सब्सिक्वेंट सूट फाइल करने के लिए तो आप कर सकते हैं, नहीं देगी यदि परमिशन तो नहीं कर सकते हैं. अभिषेक कुमार जी, अभिषेक कुमार श्रीवास्तव जी, कौन से कंडीशन है जिसमें कोर्ट के लीव, नहीं लीव के बाद भी तो वो तो लिमिटेशन उससे इसको मतलब नहीं है ना. आपका क्वेश्चन तो ऑर्डर 2 रूल 2 से रिलेट नहीं करता. यदि लिमिटेशन का बार है और कोई बार है तो अप्लाई होगा, वो तो मना नहीं है ना. डिफरेंस बिटवीन क्लेम एंड रिलीफ मैंने बताया तो आपको. ऑर्डर 2 रूल 2 का सब रूल 2 क्लेम की बात करते हैं. जैसे मैंने कहा 1 लाख रुपए का क्लेम है, 50,000 रुपए क्लेम किया, क्या बाद में 50,000 क्लेम कर लोगे? तो आंसर है नहीं. एंड रिलीफ के बारे में बोला, रिलीफ कई सारे हो सकते हैं. जैसे आपने रिलीफ मांगा कि मुझे स्पेसिफिक परफॉर्मेंस का रिलीफ दिला दो, नहीं मुझे कंपनसेशन दिला दो, मुझे प्रॉपर्टी वापस करा दो, तो उसको क्लेम नहीं कह रहे हैं, उसको रिलीफ कह रहे हैं. सर इट कैन बी फाइल्ड ड्यूरिंग पेंडेंसी ऑफ सूट. यस. डिस्टिंक्शन विद सेक्शन 10, सेक्शन 10 कोर्ट पे अप्लाई होता है, ऑर्डर 2 रूल 2 पार्टी पे अप्लाई होता है. अभी इस पर हम आएंगे. रिस जुडिकाटा भी कोर्ट को बार करती है. If a case is decided on merits, court will not hear the matter. It is duty of court. But here it is applicable now to the parties. That देखिए आपने ऐसे सूट फाइल करना है कि भाई आप पूरा रिलीफ पूरा क्लेम एक बार में लाओ. ये रिलीफ और क्लेम से रिलेट करता है, जबकि रेस जुडिकाटा इशू विच इज डिसाइडेड बाय कोर्ट से रिलेट करता है. रेस सब जुडिस. इज दिस क्लियर? अब इस पर और चर्चा करेंगे हम लोग. मेरिट वाला तो मैंने बता दिया. नहीं, केसेस पढ़ते टाइम समझ नहीं आएगा. क्यों नहीं आएगा? आज के केस आपको समझ नहीं. ये सब देखिए आपके निगेटिव थॉट्स हो सकते हैं, बच्चों को ये समस्या रहती है, आप इससे उभर जाइए, सब समझ में आता है. कैसे नहीं समझ में आएगा? इतना सिंपल केस है गुरबख्श सिंह का केस, जिसमें आपने यही कहा कि भाई ये बताओ कि ऑर्डर 2 रूल 2 को साबित करने के लिए प्लेंट नहीं लाया है, तो कैन वी अप्लाई बार ऑफ ऑर्डर 2 रूल 2? तो सुप्रीम कोर्ट ने कहा यू कैन नॉट इन्वोक बार ऑफ ऑर्डर 2 रूल 2 अनलेस अनटिल प्लेंट ऑफ अर्लियर सूट इज ब्रॉट. तो यही रेशियो है इसका गुरबख्श सिंह का. देखिए पढ़त पढ़त अभ्यास होत. हाँ, सब्सिक्वेंट सूट फाइल कर सकते हैं. यस मिस्टर अजय चौधरी. नहीं क्या है? नॉट अबाउट टुडेज बट व्हाई रेस जुडिकाटा नॉट अप्लाई टू रिजेक्शन इफ इट इज डीम्ड डिक्री. भाई डिक्री डीम्ड रिजेक्शन ऑफ, पहले तो क्वेश्चन नहीं समझ में. अंशुल सक्सेना नहीं, सवाल ही क्लियर नहीं है. नहीं ऐसे डीम्ड डिक्री, यदि आप देखो रिजेक्शन कर दोगे प्लेंट का और उसमें रेस जुडिकाटा लगा दोगे, तो रेस जुडिकाटा लगा दोगे तो फिर अगला सूट कैसे फाइल होगा? तो राइट ही समाप्त कर दिया आपने. तो इसीलिए रिजेक्शन ऑफ प्लेंट इज डीम्ड डिक्री विच इज ऑलवेज अपीलेबल, एंड ऑन विच वी कैन फाइल ए सूट अगेन. ये तो कॉमन सेंस है. यदि आपने राइट को मार दिया तो फिर अब एक बार प्लेंट रिजेक्ट कर दिया, अब उसका राइट समाप्त हो गया. अब कह दो कि भाई इनको अब हम नहीं सुनेंगे फिर से, तो बेचारा कहां रिलीफ मांगेगा? वेयर ही विल सीक द रिलीफ? ये कॉमन सेंस का सवाल है. ये कॉमन सेंस का सवाल है. जैसे एक बार आपको कॉन्सेप्ट समझ में नहीं आया तो आप दोबारा नहीं पढ़ेंगे, दोबारा नहीं समझेंगे तो कैसे होगा? तो वैसे ही कोर्ट के साथ भी है. एक बार प्लेंट को रिजेक्ट कर भी दिया गया, नो इश्यू, आप प्लेंट फिर से ला सकते हो. ऑर्डर 7 रूल 13 में कुछ ऐसा पढ़ा था हम लोगों ने, नहीं? हाँ, where rejection of plant does not preclude presentation of fresh plant, yes, अदरवाइज तो राइट ही खत्म हो जाएगा, काइंड ऑफ स्टॉपल, यस। प्लेंटी वॉमिट्स टू ज्वाइन ए डिपेंडेंट, तो बाद में ज्वाइन कराएंगे, ये तो कोर्ट की भी ड्यूटी है। आपने पढ़ा था सर ऑर्डर 1 में, ऑर्डर 1 का रूल 10 जो था, इसमें कोर्ट की भी ड्यूटी है। कोर्ट में एट एनी स्टेज, कोर्ट में एट एनी स्टेज ऑफ द प्रोसीडिंग आइदर अपॉन और विदाउट एप्लीकेशन, कोर्ट सुओ मोतो भी कर सकता है, कोर्ट भी कर सकता है, कोर्ट भी कर सकता है, कोर्ट भी कर सकता है, ऐसा नहीं है कि कोर्ट नहीं कर सकता, कोर्ट भी कर सकता है, कोर्ट भी कर सकता है। इज दिस क्लियर? इज इट ऑल राइट? जो चीज मैंने अभी नहीं पढ़ाया है आपको, उसको आगे पढ़ाऊंगा, इसलिए आप परेशान मत होएं। और आगे आगे सवाल देखिए, जैसे मैं आपको बताता हूं, दिव्यांश जी आपको आगे जाने की लग रही है जल्दी। ऑर्डर 1 का मैंने लिखा है सर रूल 3 में, मीनिंग में कि व्हेन 2 और मोर डिफेंडेंट्स आर ज्वाइंट टुगेदर एंड द टेस्ट गिवन इन रूल 3 डज नॉट सेटिस्फाई, देन ज्वाइंटर ऑफ सच डिपेंडेंट एंड देयर रिस्पेक्टिव कॉज ऑफ एक्शन, रिस्पेक्टिव कॉज ऑफ एक्शन देखिए, इज नॉन एज मल्टीफेरियसनेस ऑफ सूट। तो वो कॉज ऑफ एक्शन भी ज्वाइन नहीं होना था और डिफेंडेंट भी ज्वाइन नहीं होना था, लेकिन आपने उनको ज्वाइन करा दिया, तो मल्टीफेरियसनेस ऑफ सूट है। उस डिफेंडेंट भी दोनों अलग अलग हैं, मामला भी बिल्कुल अलग अलग है। ना डिफेंडेंट ज्वाइन होना था कि ऑर्डर 1 रूल 3 अप्लाई नहीं हो रहा, और ना कॉजेज ऑफ एक्शन ज्वाइन होने थे, क्योंकि कॉजेज ऑफ एक्शन भी दोनों के खिलाफ बिल्कुल अलग अलग है। तो उस परिस्थिति में यदि आप उनको जोड़ेंगे तो मिसजॉइंडर ऑफ कॉज ऑफ एक्शन भी है, और दूसरा वो मिसजॉइंडर ऑफ डिफेंडेंट्स भी है, क्योंकि ऑर्डर 1 रूल 3, अभी हम लोगों ने ज्वाइंडर ऑफ कॉजेज ऑफ एक्शन पर उतनी चर्चा नहीं की है, जो आगे हम करेंगे, और डोंट वरी। और कोई सवाल तो मैं नहीं, अपेलेंट अपील केस में होता है, प्लेंटिव जो है ट्रायल कोर्ट में जब केस स्टार्ट होता है, प्लेंटिव डिफेंडेंट होते हैं। प्लेंटिव इज वन हु फाइल्स द प्लेंट एंड डिफेंडेंट इज वन हु डिफेंड्स हिमसेल्फ। और जब वही केस अपील में जाएगा तो जो भी अपील करेगा वो अपेलेंट होगा, दूसरा पार्टी रिस्पोंडेंट होगा। ऑर्डर 1 रूल 8 नॉट क्लियर, ऑर्डर 1 रूल 8 तो बड़ा क्लियर है, आपके मैटर बेयर एक्ट में भी इसका नोट्स लिखा है, उसको पढ़िएगा। नहीं, इसमें कुछ ऐसा तो है नहीं, जैसे बहुत सारे लोग एक सोसाइटी में फ्लैट खरीदते हैं, तो बहुत सारी पार्टीज है, उनका सेम इंटरेस्ट है, कोर्ट से परमिशन ले लिया, सबको नोटिस दे दिया गया, सब लोग मिलकर केस फाइल करते हैं, एक ही केस हो जाता है। ऑर्डर 1 रूल 8 में तो बड़ा आसान है, देखिए ना आपके बेयर एक्ट में पेज 76 पर ऑर्डर 1 रूल 8 का टीएन हाउसिंग बोर्ड वर्सेस गणपति केस भी वही है कि देयर इज ए सोसाइटी, इन दिस सोसाइटी देयर आर 400 फ्लैट्स and there are 400 people who are affected party. Society does not give flat on time. They promised to deliver flat in 2020 June, but they did not deliver the flat in 2020 June. So what will you do? If all 400 goes to the court, so there will be 400 suits. So what law provides in order 1 rule 8 that one can go in the court as a representative or few can go in the court. But that has to be done when one goes to the court for same interest, because interest सबका same है, similar interest है, contract सबके अलग अलग हैं, कॉज ऑफ एक्शन सेम नहीं है, इंटरेस्ट सेम है। कॉज ऑफ एक्शन तो देखो डिफरेंट डिफरेंट कॉन्ट्रैक्ट है, डिफरेंट डिफरेंट कॉज ऑफ एक्शन हो गया, बट अब देखो यहां ज्वाइंटर ऑफ कॉज ऑफ एक्शन भी हो गया, समझ लीजिए ये ज्वाइंटर ऑफ कॉज ऑफ एक्शन भी है। दिव्यांश नाम था आपका, दिव्यांश जी आपने सवाल पूछा था ना, अंशुल सक्सेना जी, नहीं ये किनका सवाल था? ऑर्डर 1 रूल 1, सिमरन शर्मा, हाँ, ऑर्डर 1 रूल 8। तो ऑर्डर 1 रूल 8 में आपको बता रहा था, दिव्यांश जी का भी सवाल था कि वो भाई ज्वाइंटर ऑफ कॉरिडोर ऑफ एक्शन का क्या है। तो मैं दिव्यांशु मिस ज्वाइंटर ऑफ कॉरिडोर ऑफ एक्शन। अब यहां ज्वाइंटर ऑफ कॉरिडोर ऑफ एक्शन हो रहा है, ये मिस ज्वाइंटर नहीं है। मिस ज्वाइंटर तब होता है जब कॉरिडोर ऑफ एक्शन ज्वाइन नहीं कर सकते हम। तो ज्वाइंटर ऑफ कॉरिडोर ऑफ एक्शन भी है, ज्वाइंटर ऑफ पार्टीज भी ऑर्डर 1 रूल 8 में उस प्रकार से। बट नाउ लॉ सेज दैट टू नाउ सेव टाइम ऑफ द कोर्ट एंड टू सेव द पार्टीज आल्सो, इफ देयर इज सिमिलर इंटरेस्ट, कम्युनिटी ऑफ इंटरेस्ट, व्हाई नॉट वन पर्सन कैन फाइल द केस ऑन बिहाफ ऑफ ऑल, बट फॉर दैट कोर्ट्स परमिशन इज रिक्वायर्ड। For that court's permission is required. This permission can be sought even later on, and notice to all parties are should be served. If there are many parties, notice will be served by public advertisement. If there are few parties, we can send notices to them so that they can protect their interest. And if they think that their interest is not protected, they can approach the court directly and they can say that मैं भी केस में आना चाहता हूँ। बहुत सिंपल चीज है ये। TN हाउसिंग बोर्ड वर्सेस गणपति। सिमरन शर्मा, डिड यू अंडरस्टैंड? कुछ है नहीं। देखो होता क्या है ना, कब सर ने इसको टच नहीं किया तो आपको लगा बड़ा कठिन है, ऐसा कुछ भी नहीं, बहुत सिंपल बात है ये तो। ऑर्डर 6 रूल 13 आपने लिखा है पूजा दुबे, प्रिजम्पशंस ऑफ लॉ को प्लीड नहीं करना होता है। लॉ में बहुत जगह प्रिजम्पशंस हैं, जैसे ये जो एग्जाम्पल दिया, एग्जाम्पल गिवन इन ऑर्डर 6 रूल 13 डील्स विद प्रिजम्पशन ऑफ लॉ। नाउ लॉ गिव्स मेनी प्रिजम्पशंस, लाइक लॉ हैज ए प्रिजम्पशन इन नेगोशिएबल इंस्ट्रूमेंट एक्ट दैट इफ नेगोशिएबल इंस्ट्रूमेंट इज देयर इट हैज I have not left my dear friend मैंने कहा भी था आपको, आप इसको पढ़िएगा, उसमें कुछ है ही नहीं, मैंने तो नोट्स लिख दिया, अभी भी बता दिया सर यू हैव लेफ्ट। इससे लग रहा है सर को पढ़ना, आपको नहीं। अरे आप पढ़ो ना सर यू हैव लेफ्ट, जैसे सर ने कोई अपराध कर दिया अरे भाई पढ़ाई तो ऐसी होनी चाहिए जिसमें एक आध टॉपिक तो आप अपने से भी पढ़ोगे हैं। इतना अच्छा सर ने राइटिंग लिखा है, इतनी अच्छी चीज लिख दी है, उसमें कुछ है ही नहीं। उसमें तो बाकी सब चीजें खाली रिप्रेजेंटेटिव कब बनेगा तो मैंने बता दिया जब कम्युनिटी ऑफ इंटरेस्ट हो। तो मैंने नहीं पढ़ा तो मैंने आज पढ़ा दिया आपको। शुभम चौहान, इतना बाल्ड एलिगेशन, वेरी गुड ऑर्डर 1 रूल 10 सब रूल 2, ऑर्डर 1 रूल 10 सारा पढ़ा दिया आपको। देखिए आप, यही भ्रम है ना। देखो पोथी पढ़ी पढ़ी जगमुआ पंडित भयानक होए। मैं देखता हूं कि आप भ्रमित हो, थोड़ा सा भ्रम से निकलो। जो मैं पढ़ाता हूं ना, आप उतना पहले ध्यान से पढ़िए। मैंने आपको सब कुछ पढ़ा दिया सर, आपको अब यही तो विश्वास करना, नहीं तो ऐसा तो आप भ्रमित। एक बच्चा आया ऐसी आईपीसी में, कहा कि 550 सेक्शन है, 70 है, सब पढ़ाएंगे सर। अरे जिस दिन 570 सेक्शन कोई बच्चा पढ़ने लगेगा वो तो बिल्कुल परेशान हो जाएगा। वो तो जो 50 सेक्शन इंपॉर्टेंट है वो भी गायब हो जाएगा और 520 बेकार की चीजें पढ़ लेगा। आपको चौहान साहब ये सब चीजें समझनी है, समझोगे मेरी संगति में। अभी पूर्ण आस्था और विश्वास के साथ पढ़ो। मैं बहुत ही सच्चाई से आपको कह रहा हूं, यदि आप बार बार भ्रमित होते रहेंगे कि सर ने ये छोड़ा। देखो ऑर्डर 1 रूल 8 का कितना अच्छा मैंने आपके लिए मीनिंग लिखा है। मेरी जिंदगी खराब हो गई इसमें, मेरा आंख खराब हो गया, ब्लड प्रेशर हो गया, डायबिटीज हो गया, सब कुछ। मैंने इतना टेंशन पाल रखा है इस बेयर एक्ट को लिखने में, आज भी टेंशन में चल रहा हूं, इसलिए कि आईपीसी का बेयर एक्ट समय से नहीं आया। परेशान हूं, सुबह ही पब्लिशर को फोन किया, प्रिंटर को, वो अभी भी 3 दिन का समय मांग रहा है। एसआरए का काम नहीं हो पाया, बहुत व्यथित हैं, दुखी हैं। मुस्लिम लॉ मेरा पढ़ा हुआ है, पिछले 2 महीने से 3 महीने से लॉकडाउन में ही कर दिया था, नहीं हो पाया। परेशान हूं, बट आप शायद उस चीज को नहीं समझ पाएंगे कि मैंने कितनी मेहनत की है। ऑर्डर 1 रूल 8 आपको बहुत बढ़िया से लिखा हुआ है बैरक में। अब तो ये एलिगेशन है, आप शिक्षक को जितना चाहो उतना एलिगेशन लगा सकते हो, आपने ये नहीं पढ़ाया, आपने वो नहीं किया। हमने कुछ नहीं छोड़ा, और यदि छोड़ा है तो आज सर कर दिया है। मुझे काम की बात बताने दो, इन सब चीजों में मत फंसाओ। मेरे दिमाग में है कि मैंने क्या किया है नहीं किया है। मैं जो प्रश्न बता रहा था सर, क्या बता रहा था मैं भूल भी गया। हाँ, ऑर्डर 6 रूल 13 का सवाल मैंने लिया था। आपका था सवाल ना, पूजा। तो मैं बता रहा था आपको ऑर्डर 6 रूल 13। देखो, प्रिजम्पशन है लॉ में बहुत सारे, जैसे प्रिजम्पशन है कि जिसका जिसने भी निगोशिएबल इंस्ट्रूमेंट लिखा है, जैसे प्रॉमिसरी नोट लिखा, बिल ऑफ एक्सचेंज लिखा, वो हमेशा कंसिडरेशन लेके ही लिखा। So consideration is involved in negotiable instrument, that is presumption of law. Now, are you required to plead this in pleadings? The answer is no. The answer is no. Order 6 rule 13 says, हर चीजें आप सीखोगे ना समय से। Neither party need in any pleading allege any matter of fact which the law presumes in his favor, or as to which burden of proof lies upon the other side, unless the same has first been specifically denied. अब यदि मान लो कंसिडरेशन को कोई डिनाई कर दे, तो फिर हम दिखाएंगे कि कंसिडरेशन था, अदरवाइज कंसिडरेशन इज प्रिज्यूम्ड इन निगोशिएबल इंस्ट्रूमेंट। शुभम चौहान साहब, थैंक यू। हाँ भाई, कंटिन्यू करोगे, ठीक है, कहे थे। इतना मेरे को क्यों इतना वो करते हो भाई, ड्रैग करते हो ना? समझा करो भाव को। मुझे पढ़ाने दो यार, मुझे पढ़ाने दो। आप पता नहीं किस, मैं कई विद्यार्थियों पे मुझे अफसोस होता है, वो मुझे ड्रैग करना चाहते, खींचना चाहते हैं पीछे। जैसे सवाल के, अब किसी ने शिकायत की होगी विजय जी से कि भाई सर ने पता नहीं कुछ डांट दिया। मैंने कब डांटा मुझे खुद भी याद नहीं है, बट आप मेरी जो है वो रेपुटेशन खराब कर रहे हो। आपकी मर्जी है, आप मालिक है, मैं कुछ नहीं कर सकता। कंपनी मेरे पैसे काटेगी, कुछ और होना है नहीं। मेरे बारे में यही कहा जाएगा कि आपने क्लास ठीक से नहीं चलाई। हालांकि आई एम पुटिंग माई बेस्ट एफर्ट इन दिस क्लास, आई एम डूइंग माई बेस्ट, बट इवन देन मेरा रिवॉर्ड चला जाएगा। मर्जी आपकी है, मालिक आप हैं। कल हम फिर पढ़ते हैं ऑर्डर 2 रूल 2। मुझे आपके किसी बात का बुरा नहीं लगता। मैं बहुत खुश हूं चौहान साहब, मैं बहुत खुश हूं, सबसे खुश हूं, आपसे भी खुश हूं। मैं आपके सारे प्रश्नों का जवाब दूंगा, ठीक है? लेकिन ये मत कहिए छोड़ दिया वो छोड़ दिया। अदरवाइज मेरे को एक बच्चा बोल के गया कि भाई आपने आईपीसी में तो 300 सेक्शन छोड़ दिए। मैंने कहा कौन से 300 सेक्शन, मैंने तो आईपीसी पूरे पढ़ा दिए। उसने कहा 300 सेक्शन छोड़ दिया। मैंने कहा कभी एग्जाम दिया है? उसने कहा नहीं। मैंने कहा मैं जिंदगी भर एग्जाम दिया हूं और एग्जाम दिलवाता रहा हूं और कई सारे टॉपर बना चुका हूं, आगे भी बनाता रहूंगा। इसलिए मेरी बात ज्यादा इंपॉर्टेंट है, मेरी समझ ज्यादा वो है या तुम्हारी? मान लो भाई मेरी बात, मेरी समझ ज्यादा महत्वपूर्ण है। मैं आपको जो बता रहा हूं आप उस रास्ते पे चलिए, आप जरूर टॉप करेंगे, ये मेरा विश्वास है। मेरे हर विद्यार्थी इस क्लास के बहुत अच्छा करेंगे, मुझे पूरा विश्वास है। लेकिन थोड़ी सी गलती मत करिएगा, नहीं तो आपको समय 1 साल के बजाय 2 साल लग सकता है, 3 साल। मैं जितना पढ़ा रहा हूं उतना ही पढ़िएगा। इज दिस क्लियर सर? थैंक यू वेरी मच, गॉड ब्लेस यू ऑल। आज की क्लास कैसी लगी ये मुझे बता दीजिएगा। कोई चीज नहीं समझ में आई कल फिर पूछ लीजिएगा, मैं आपके सामने आऊंगा। बट बता दीजिएगा आज की क्लास कैसी लगी आपको, ठीक लगी, क्या इंप्रूवमेंट चाहिए मैं करूंगा, डोंट वरी।